Hello, may I crave your lordship indulgence in respect of item 1, my lord? I'm taking for a slight omission. There's a matter in court number 1 immediately.
Make it lordship. But if in item number 6, you'll file an affidavit, which that may be called for item. I did on Tuesday.
You file it.
File it on Tuesday.
When?
Tuesday, not on 2nd of April.
Okay, very well. Then
Well, I want that this may be called. Are you? I have a similar question. In item number 15, my lord, I have filed an affidavit regarding justice service.
15.
Item number 15, yes. Yes. You want say that matter be passed over for the time. My senior is in court number 2, my lord.
I'm supposed to pass the judgment on.
My lord, there are 3 points which my senior wanted to address.
You have missed the opportunity.
My lord, then,
I can't help it.
my lord, then I may be allowed to raise those points.
Yes.
Pick it up there. My lord, first submission which I would like to say is that the schedule A and schedule B which the learned first appellate court had set in the point of limitation that article 67 would apply. In that regard, my lord, I would like to take the lordship to the exhibit 2 of the plaintiff's, my lord, which is the judgment passed by the learned first appellate court in the earlier suit. My lord, at page number 7, there was a finding which was brought. My lord, I may be allowed to read it. It is crystal clear that the tenancy khatiyan was without any basis of law, and moreover, the defendants were put for possession of a house by plaintiff for doing business, running a tea shop, and it was on monthly rental basis. That for non-splitting the land of monthly tenancy and the land of trespass and the land under Suresh Bedova, relief for eviction on trespass land separately cannot be passed. And there was no notice for evicting the defendant from jointly tenancy premises. Hence, the London Municip rightly did not grant the relief of injunction, but as regard decision of Khatiyan is found to be correct, as it was arbitrarily and illegally granted in the names of the defendant. Lord, the first appellate court had held that there were 2 distinct plots of land. One was under tenancy and one which will be the appellant statement at trespass. But that was the finding which was given in the previous. Now, if for a moment we take that the Schedule A land is covered under Article 67, my submission is that the Schedule B land, which is said to be we have trespass, my lord, will come under Article 65 of the limit. So now, my lord, the question before this honorable court will be that
How can 65 come into the picture?
My lord, it is
When you have claimed the Khatiyan,
my lord, the Khatiyan is cancelled, my lord.
whatever may be, you claim the Khatiyan on the basis that he is the owner.
My lord, that also, my lord.
Tenant is always a tenant.
My lord, in the plaint itself, my lord, plaint and the written statement, I'd like to just your lordship to that. If your lordship may come to the plaint, my lord. Paragraph 4 of the plaint, my lord, which is at page number 53, my lord.
Page
53 of the memo. Internal page 4 paragraph. My lord, I can be allowed to read this paragraph.
Yes.
That while in occupation of the tenanted houses as monthly tenant, the original tenant late Harendranath Deka, predecessor in interest of the present defendants, numbers 1 to 6, illegally and unauthorizedly affixed asbestos sheets on the roof of one of the 2 tenanted thatched houses. Beside affixing asbestos sheets, the said tenant also illegally and unauthorizedly constructed on 15/8/75 2 thatched houses upon the vacant plot of land, measuring about 8 lechas, being a part of the measuring land measuring 1 kattha 19 lechas belonging to the plaintiff, are the existing tenanted. The said tenant made those unauthorized construction in gross violation of the terms of the tenancy, and as such, the said tenant forfeited his right as tenant and rendered himself liable to be evicted from the tenanted house and also by demolishing the illegally constructed two houses over about 8 acres of adjacent vacant land belonging to the plaintiff. The land upon which the said tenant illegally constructed the aforesaid two thatched houses and which are now in occupation of this land fully described in the schedule B below.
Mr. Bhatt, when did you obtain the Khatian?
Plot 76.
Correct. Then also you claimed he is the owner. After 75 also, in 76, when you obtained the tenancy, the Khatian, saying that he is the landlord, then also you claim that he is the owner. Isn't it an acknowledgement to him as the owner? Once you acknowledge him as an owner, where is the question of adverse possession?
My lord, then in that case, my lord, in respect of the schedule A, I'd like to submit one more thing, my lord. My lord, schedule A also, my lord, the London First Appellate Court had held that it will come under Article 66. As per my commission, my lord, it will come under Article 66. How? Lord, in that regard, my lord, I'll take your lordship to the notice which they had issued, my lord, Exhibit 3.
Yes, what are you saying?
My lord, the second, my lord, submission is that in respect of the schedule A, my lord, sort of land. The learned first appellate court had held that the exhibit number 3, which was the notice issued by the plaintiff, was under 106. My lord, I'd like to just bring your lordship notice to the notice for. Lord, there is a paragraph wherein page number 3 of the notice that while in occupation of the tenanted premises as monthly tenant, you also unauthorizedly affix a vested sheet on the roof of so and so houses of the tenanted.
Mr.
My lord,
Atra, are you aware of the fact that I am in second appeal?
yes, my lord. My
Then
lord,
why should I look into all these things
Lord.
unless you are alleging perversity?
Lord, I,
Have you alleged perversity on that issue?
Lord, so far
Have you alleged perversity on that issue? If you have not, why should I look into the evidence?
my lord,
This is not a first appeal.
my lord, we had read there's an issue regarding, my lord, whether 66 or 67 would lie, my lord. I am saying that, my lord, it is a forfeiture, my lord. It will come under 111G, not 150. Because in their notice itself, they have stated that that you had constructed 2 thatched houses. near-
67 only comes into play when it is a case of statutory tenant.
Yes.
Then
My lord, in our case, my lord, they had said that we had violated the terms of the tenancy, my lord. And they had forfeited, my lord. There's a paragraph in the notice, my lord, where they have stated that because of such unauthorized construction made by you, you have forfeited your rights as a tenant, and you are liable to be evicted from the tenanted premises by demolishing 2 thatched
Mr.
houses.
Counsel, why you are not understanding? 67 comes into the plane when you are a statutory tenant. Are you a statutory tenant?
My lord, but I'll
Are you a statutory tenant? What do you mean by a statutory tenant? A statutory tenant, then you have to determine them. Then only it comes from the date of determination. But does it apply to a statutory tenant? Are you a statutory tenant? Is it your case that you are a statutory tenant? Is there any pleadings to that effect for 67 to come in?
Lord, so far as my lord, the is concerned, Lord, we are tenants that has been pulled by the previous that we've been in this.
But are you a statutory tenant? I'm asking you. Is a difference. If you are not a statutory tenant, then 67 does not come, 65 comes in. But if you accept the tenancy out there, then you cannot, a tenant is always a tenant.
My lord, but then 66 will come, my lord, because
How do you come with 66? 66, when 67, there is a specific thing for a tenant.
my lord, but we say, my lord, there is a forfeiture, and in the plain they have stated that 1975 only we had constructed. In their letter itself, their own notice, they have stated that there are rights as a tenant are forfeited.
Ali, there is a judgment on this 66, 67. It's a new judgment. I forgot. I'm not getting it.
New judgment.
The new judgment in 2021, I suppose, on Article 66, 67. The Supreme Court very nicely explains this thing, how it is. And when there can be a forfeiture, why 67? Why there is a reason that 65, 66 cannot be applied to a tenant because of 67. But 67, there is again a judgment to that effect that it only applies to a statutory tenant. It cannot apply, and as such, he has to go to 65.
Your lordship, it is dependent upon the determination. Where it was determined, sector Article 67.
Understood, but that is only for statutory tenant. Is he a statutory tenant?
Statutory tenant or otherwise, your lordship.
No, not otherwise. 67 does not apply to others.
So from the date of determination, your lordship, it is to be filed within 12 years.
from the date of determination.
Lordship. It is,
Yeah.
in the year 1992, your lordship, it was determined.
Hmm?
75, my lord. It was determined on 8/3/1992,
No, that is why I'm saying.
and suit was filed in 1992 itself. So from that angle, and there is to be officer, your lordship, there must be.
No, there is a judgment to the effect why 60 in respect to a tenant. 66 does not apply.
One judgment is there of 1987, 3 SCC.
Because
Page
66 applies in respect of, doesn't apply to a tenant. And that is why the Supreme Court said this judgment came sometime in, I think, 2021. Yes, 21. This judgment came in 2021. It's a three judges bench. I think it is by Justice D.Y. Chandrachud. Very nicely it explains. Like for this, for example, you are referring to 87. 87 has already been distinguished by the
Lordship.
Supreme Court in 2007. In possession asserting his title, ownership of landlord not disputed, burden of proof to establish title. On facts, respondent number 3 landlord admittedly owner, respondent number 1 tenant claiming title by reason of oral gift or adverse possession, and ownership of a respondent was not disputed, held burden of proof of the title was on the so and so. Then our 87 has been distinguished. Kindly see here. Yes, paragraph 29. Reliance has been placed by Mr. Parasaran on Article 67 of the Limitation Act and is also not opposite. It is a special provision. It would only apply in a case where a tenant has ceased to be a tenant in terms with the provisions of the Andhra Pradesh Rent Control and Eviction Control Act. A tenant continues to be a tenant despite termination of the tenancy. Article 67 would not be attracted in a case where a tenant remains a statutory tenant. In a case of this nature, Article 65 would apply. As the claim of the respondent was based on title, the onus was on him to prove the title. Respondent number 1 failed to discharge the same, and therefore the learned trial judge was, in our opinion, had committed an error, no error in passing the decree in favor of the plaintiff. Then they rely on this judgment which you are referring to, the 87. 87 says that if that is so, then on strict grammatical meaning, Article 67 of the Limitation Act would be applicable. This is indubitably a suit by landlord against a tenant to recover possession from the tenant. Therefore, the suit clearly comes under Article 67 of the Limitation Act. The suit was filed because the tenancy was determined by the combined effect of operation of 12 and 13 of the Bombay Rent Act. In this connection, the terms of section so and so may be referred to at the most it would be within 66 of the Limitation Act if we hold that a forfeiture has been incurred by the appellant in view of the breach of the condition mentioned in 13 and on lifting of an embargo against the eviction of the tenant in terms with section 12 of the act. That being so, either Article 66 or AR would be applicable to the facts of this case. There is no scope of it. The said decision, how does the Supreme Court say? The said decision has no application in the facts of the present case, as there is nothing to show that after the expiry of the period envisaged in the lease, and despite the fact that the respondent itself has been paying tendering monthly rent, there has been a final determination of the tenancy pursuant whereto the respondent was required to hand over the vacant possession to the landlord. Nothing has been brought on record to show that the landlord has served any notice directing the tenant to hand over the vacant possession upon valid termination of the lease. Whereto our attention was drawn, this court came to an conclusion that the civil court has no jurisdiction to try a suit of rent control.
So 66 is not applicable, there is no forfeiture as such. No.
Hmm.
So to be a forfeiture, your lordship, there is not.
Their forfeiture basis is in 1975 it has happened. But when they obtained the Khatian in 1976, wouldn't there be that they have already acknowledged?
So they don't have lack to stand your lordship. This 65 goes as soon as they obtain the Khatian.
65 goes, but what about 67?
67, so far 7 is concerned from the date of determination. From the date of determination, 1992, your lordship should have been filed in the year 1992 itself. 12 months limitation. From that angle also, they don't have any case, your lordship.
But how do you take care from 1975?
No.
How do you take care when you have made a statement in your plaint that there has been that he has forfeited his right in 1975 when he constructed those?
This forfeiture, this is literal meaning also. This forfeiture, so far this Article 66 is concerned, that is a different thing because that is defined again under Article Section 111 of this Trust for Property Act. That forfeiture means, your lordship, under section, under Article 66.
Hmm.
So for this forfeiture, your lordship, that is not expected because that forfeiture is something else and that is a literal, your lordship,
Hmm.
not legal one, your lordship.
That is a
Not a, it doesn't carry any legal meaning, this forfeiture, your lordship. Legal meaning, so far forfeiture is concerned, it is under Article 66. And that has again been defined under Section 111. The specific conditions must be there and those are violated. This forfeiture is something else, your lordship, that you are no longer entitled to get any benefit under it. This is the second appeal, your lordship, concurrent finding.
You mean to say that second appeal with concurrent finding, I should shut my eyes?
No, not that, your lordship. This so far they are raising the
You
point.
say so, okay, very well. I'll also apply the same yardstick with you.
This is a case on facts, your lordship, basically.
No, understood. But the question is, when it is an admitted fact stated in paragraph number 4 of your plaint that there is a forfeiture, the question arises whether it will come under 66 or 67. Now that judgment you are not placing it. Huh? I got that judgment while I was practicing just before elevation. That judgment I got that, which categorically shows the difference between very nicely. When I actually a forfeiture happened, I am not getting it. Is I referred to. Yeah, right. Good. Hmm. Yes, I got. This is the. It is not by the it is by Justice Heman Gupta. Nanram State versus Jagadish. 2029 SCC 393.
2029 SCC.
2029 SCC 393.
Please, Your Lordship.
393. Yes. Here the question here, kindly see here. How does the interplay between 66 and 67? 393. The entire thing has been dealt with. Give me a copy of it or a printout like it.
Lord, I have one.
You have it?
I was thinking, my Lord, he does it better. Lord.
Yeah. I give it to him. Mr. Ali, kindly see. We have heard the learned counsel. The question that is required to be examined is as to which article of Limitation Act would be applicable in the present case, Article 65 as asserted by the applicant, or Article 66 or 67 as asserted by the respondent, and that from which date the period of limitation would commence. Then the court deals with everything and then comes to finally come to paragraph 39. Does the suit of a plaintiff filed within 12 years of the determination of a tenancy by a flux of time is within the period of limitation? The defendant has not proved forfeiture of tenancy prior to the expiry of the lease period. Mere non-payment of rent does not amount to forfeiture of the tenancy. It only confers a right on the landlord to seek possession. The plaintiff has filed a suit for possession against the defendant on the basis of a determination of tenancies. Have you got it? Paragraph 39. Yes, kindly. It only confers a right on the landlord to seek possession. The plaintiff has filed a suit for possession against the defendant on the basis of a determination of tenancy such is governed by Article 67 alone. In view of the above, the suit is for possession, which would not be covered under Article 65, since there is a specific article, Article 67, dealing with the right of a lessor to claim possession after determination of tenancy. The appellant plaintiff has claimed a possession from the defendant alleging him to be a tenant, and he has not handed over the lease property after the determination of the lease. Therefore, such a property suit would fall within 67, and such a limitation would be on so and so within 12 years from the date of determination of the lease by a flux of time on so and so. The same is within the period of limitation. Now here, again he leads to 66. Kindly come to 43. In view of the fact, we find that the High Court erred in law in holding that a suit is based by limitation in terms with 66. Therefore, so and so. Kindly see here, here. Though Mr. So and so, the learned counsel, that the first appellate suit debated as so and so, the respondent continued to be in possession of the land leased by so and so. The respondent has admitted the ownership of the before the reference court. Such plea operates as an estoppel against the respondent in respect of the title of the appellant. However, the claim of possession, compensation put forward by the respondent was declined by the reason that non-payment of the rent disentitles the respondent from the compensation. In the present proceeding, the respondent have denied his status as that of a tenant, but claimed title in himself. The respondent claimed adverse possession and claimed possession as owner as a person who had inducted him as the tenant. The respondent was to prove his continuous, open, and hostile possession to the knowledge of the true owner for a continuous period of 12 years.
This, he has a subordinate decision of that decision.
Huh?
Those pages are not with him also. And the copy given to me there also. Anyway, your lordship, I am hearing.
You read it.
That is actually not here in this argument.
No, my lord, it's under a- lord, it's under a-
No, no.
What is this question?
No, he was reading the other paper.
Anyway,
Lord,
How does the Supreme Court take into account 166? Is this Article 66 also is?
So, Your Lordship, para 39 and 40, it is specific, Your Lordship,
Yes, that is what I am saying.
specific.
Mr. Ali, kindly come to page 422. You have got the SEC version? 422 of that judgment. Page 422 there.
Your Lordship, paragraph, Your Lordship, it is pages are
Just above paragraph 39, there the Supreme Court approved the judgment of the Delhi High Court in the case of MEC India, paragraph 38.
38, Your Lordship.
Just then there, paragraph 45, 46, 47, do you see that?
Lordship.
Kindly come to 48. This is a very important aspect. Thus, a tenant at sufferance is one who wrongfully continues in possession after the extinction of lawful title, and that a tenancy at sufferance is merely a legal fiction or a device to avoid continuance in possession from operating as a trespass. A tenant remaining in possession of the property after determination of the lease does not become a trespasser, but continues as a tenant at sufferance till possession is restored to the landlord. The possession of an erstwhile tenant is jurisdictional, and he is protected from dispossession otherwise than in due course of law. Although he is a tenant, but being one at sufferance as aforesaid, no rent can be paid, since if rent is accepted by the landlord, he will be deemed to have consented, and a tenancy from month to month will come to in existence. Instead of rent, the tenant at sufferance and by his mere continuance in possession is deemed to acknowledge both the landlord's title and his liability to pay mean profit for the use and occupancy of the property. To sum up the legal position or status of a lessee whose lease have been expired or who continues is not assented by the landlord is that of a tenant of sufferance. If, however, the holding over has been assented in any manner, then it becomes that of a tenant from month to month. Similar, that is, from month to month is the status of tenant lessee who comes into possession under the lessee for a period exceeding 1 year but unregistered. He holds it as so and so. Now kindly see here again 39. Thus, the suit of the plaintiff filed within 12 years from the determination by a flux of time is within the period of limitation. The defendant has not proved forfeiture of tenancy prior to the expiry of the lease period. Mere non-payment of rent does not amount to forfeiture of tenancy. It only confers a right on the landlord to seek possession. The plaintiff have filed a suit for possession against the defendant on the basis of determination of lease, and such a suit is covered by.
So that's why for this forfeiture, your lordship is different forfeiture. As
So it would not be a forfeiture.
correct, your lordship. So we are using the word forfeiture in paragraph 4, your lordship. They can't reap any fruit out of it, your lordship, to their benefit. So this decision, your lordship, supports.
Now let us see their pleading, what they have done, because they have to base their on the basis of this, not the pleadings of the plaintiff. Let's see what the defendant say in his plea. Now kindly come to paragraph 9 of your written statement. You are relying on paragraph 4 of the plaint. Now let's see what you say in paragraph 9.
Admitted.
No, they deny. They deny the forfeiture.
Lordship.
See.
That the statement made in paragraph 4 of the
Are entirely baseless and unauthentic.
So you deny what the plaintiff said about the forfeiture. And now you want to clamp on that. My goodness. Let's see what is their case. Cannot claim any relief in the. Where is your basis about forfeiture? There has to be a foundation. Mr. Butler, where is the foundation for forfeiture under 66? Show me. The basis on which you did it, you are denying that. So you have to have a foundation. Where is your foundation?
In the statement, you have merely denied the.
So your only claim is under 65. If it is under 65, and you are saying adversely to the true owner, are you not admitting his claim, right?
In respect of the schedule A, but
Forget about Schedule A. Have you differentiated Schedule A, B in your written statement? You say the entire land from your forefathers, you have been doing it. Kindly come to paragraph 12. can you raise all these things? Hello? Enough. What else? Let me start to dictate it. I think this is your catch judgment, 2020. I remember just before my elevation, I got through this judgment at that point of time for some matter.
Relied upon a judgment whereby our appeal was dismissed. Moti Kumari.
Huh?
But there was an order passed by Lordship only. Relying on that judgment, Moti Kumari Fraud. My senior was a
Which one?
Another case, your lordship, 2 years ago. One motive,
sir and my.
Oh, that is, in fact, if you see the trial court should have decreed the suit in the first stage itself, isn't it, Mr. Ali?
that decision supports my case.
Understood? No, not only that, not these proceedings. In the earlier proceedings only, the trial court should have granted the decree in your favor.
Correct.
Because the question of splitting then also can be done in view of 109. Assignee a part of a reversion can exercise all rights of a landlord in respect to the portion of area. Splitting of the unity and integrity of a tenancy and recovery of possession of a part is permitted subject to the application of section 109. So in fact, in the first litigation, you should have got that relief. You have been denied. So 10,000 per year, we put it from 1975.
That will do it.
That would be the cost. I dictate in Mr. Batra, you calculate the cost. Therefore, the instant appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 29/2008, passed in title appeal number 9/1998, whereby, why it is of 2011? Oh, yeah, 9/1998, whereby the appeal filed by the applicants was dismissed, and the judgment and decree dated 27/1/1998, passed in title suit number 141/92 by the Court of the Civil Judge Junior Division, number 1, Guwahati. Presently, the Court of the Munsif, number 1, Guwahati. Now it is Munsif, na? Junior Division. Yeah, I got it out. By the Court of the, but everywhere it's Munsif. No, not Munsif.
Junior division and senior division.
Okay. By the learned civil judge junior division number 1 at Guwahati was affirmed. Apunar juntu agote diluna civil judge number 1 Kamrup Metro at Guwahati, make it first appellate court, for short referred to, for the sake of convenience, referred to as the first appellate court. Or it is mentioned koilu civil judge junior division number 1 Guwahati, the second appellate, or the learned trial court. This court, while an order dated 11/3/2011, admitted the appeal by formulating 4 substantial questions of law, which reads as under it. The question as to whether those four substantial questions of law which have been formulated by this court are involved in the instant appeal. This court finds it relevant to take note of the background which led to the filing of the instant appeal. The predecessor in interest of the respondents herein filed a suit before the court of the Munsif at Guwahati, which was registered and numbered as title suit number 141/2022 against the appellants herein. The plaintiffs in the said suit claim to be joint owners and pattadars of a plot of land measuring 1 katha 10 lechas, covered by dag number 693 of Khira's patta number, Khira's periodic patta number 43, situated at village Bejera under Moza Borbongs BARBANGSHAR in the district of Kamrup. The plaintiffs claim that they had constructed 3 thatched houses upon the said plot of land and let out the same to various tenants on monthly rental basis. It was mentioned in the plaint that the defendants in the said suit were the sons and daughters of one Horendra Nath Deka, since deceased, who took 2 out of the 3 thatched houses from the plaintiffs on an oral agreement to pay monthly rental of rupees 40. The said tenancy commenced from the month of January 1973. During that period of time, late Horendranath Deka used those tenanted premises for the purpose of running a tea stall. Thereupon, after the death of late Horendranath Deka, the defendants continued to be in occupation of the 2 thatched houses, two houses, as monthly tenant under the plaintiff. The said thatched houses have been more specifically described in Schedule A to the plaintiff. Sometime in the month, it was further alleged in the plaint that sometime in the month of August 1975, the predecessor in interest of the defendants defaulted in payment of the monthly tenanted monthly rent. Subsequent to the death of late Horendranath Deka, the defendants stopped making payment in respect to the Schedule A houses since the month of August 1975. And as such, it was stated that the said defendants were defaulters. It was also mentioned in the plaint that the defendant numbers 1 to 6 illegally and unauthorizedly affixed asbestos sheets on the roof of one of the two tenanted thatched houses, and also illegally and unauthorizedly constructed on 15/8/1975 two thatched houses upon the vacant plot of land measuring about 8 lechas, which was a part of the land measuring 1 katha 19 lechas belonging to the plaintiffs. These 8 lechas of land have been specifically described in Schedule B to the plaintiff. It was also mentioned that during the lifetime of the father of the defendant, during the lifetime of late Horendranath Deka, he, along with the defendant number 7, entered into a collusion with the land record staff and surreptitiously obtained a khatiyan in respect to the entire land over which the tenanted houses stood. When it came to the notice of the plaintiffs about the issuance of the illegal khatiyan obtained by late Horendranath Deka and the defendant number 7, the plaintiff instituted a title suit, being title suit number 44 of 1985 in the court of the learned Munsif number 2, Guwahati, against the defendants for cancellation of the said khatiyan and also for eviction of the defendants from the tenanted premises described in Schedule A below, Schedule A to the plaintiff. During the pendency of the said suit, the said late Horendranath Deka expired, and therefore the defendant number 1 to 6 continued to occupy the land and houses standing on Schedule A land. Full stop. It is further relevant to take note of from a perusal of the play that the defendants duly contested the said suit, being title suit number 44 of 1985, and the said suit was partly decreed, thereby holding that the issuance of the Khotian in favor of late Horendranath Deka and the respondent number 7, and as well as the defendant number 7, was illegal and the defendants were held to be monthly tenants in respect to the tenanted house. However, on account of However, no decree for eviction of the defendant was passed on the ground. Where is that order of the trial courts? I think it is exhibited documents.
Non-service of notice.
Exhibit 1 and
Non-service of notice.
non-service and non-splitting,
Non-service and
non-splitting of the.
However,
Non-splitting.
the relief of eviction was not granted. Itu line to line. The learned trial court by judgment and order dated, judgment and decree dated 1910-1985 partly allowed the said suit. It is relevant to take note of that in the said suit, four issues were framed. Which included as to whether the defendants were tenants under the plaintiff for the houses in question, and as to whether, and the issue number 3, that is whether the defendants were tenants under the plaintiff under the Assam Tenancy Act 1971. The learned trial court, while deciding the issue number 2 and 3, came to an opinion that the Khatian, which was the subject matter of challenge, could not have been issued as the land was used for business purpose by running a tea stall. And by letting out houses constructed thereon, as was apparent from the evidence of the defense witnesses. The learned, the, the trial court further arrived at the conclusion on the basis of the evidence that the defendants were in possession of the plot of land as a permissive occupier, but no terms of tenancy appears to have been created between the parties. Here the court did not say anything whether to be evicted or not in this thing. I think it must be in appeal or something.
Court, my lord, lastly, it was said.
Also, being aggrieved. The defendants herein preferred an appeal against the judgment and decree dated 1910-1985 before the title suit, in title suit number 44/85, before the court of the assistant district, before the court of the assistant district judge number 1, Guwahati. The said appeal was registered and numbered as title appeal number 49/1985. The learned first appellate court came to an opinion. The learned first appellate court affirmed the judgment and decree passed by the learned trial court by its judgment and decree dated 27/10/1990. In dismissing the appeal, the learned First Appellate Court held that the issuance of the tenancy khatiyan in favor of the defendants herein, the defendants in those proceedings who are also the defendants herein, was without any basis of law. It was categorically observed that the defendants were put for possession of a house by the plaintiff for doing business, running a tea shop, and it was on monthly rent basis. However, on account of non-splitting the land of monthly tenancy and the land of trespass, and the land under Suren Bedge, relief for eviction on trespass land separately cannot be passed. And there was no notice for evicting the defendants from the monthly tenancy premises. And as such, the learned First Appellate Court held that the learned trial court was therefore justified in not granting the relief of eviction and granting the relief on the illegality of the khatiyan. The said dispute, the said judgment therefore attained finality, thereupon attained finality, as there was no appeal filed there against. Therefore, from the said judgment passed by the learned First Appellate Court, two aspects there comes to light. First,
There was second appeal.
what happened?
That is second appeal 52 of 1991. That was judgment of delivered on 17/7/96, dismissing the appeal.
Did the court say anything?
Lordship,
Did the court say anything else, or merely dismissed it?
dismissed, Your Lord. Dismissed.
It has also been brought to the notice of this court that a second appeal was prepared, being second appeal number
52 of 1991.
20 before this court, which was, however, dismissed by this court by the judgment and decree dated
17/7/96.
17/7/1993.
17/7/96. 96.
96. Without interfering with the judgment and decree passed by the learned First Appellate Court. Therefore, from the free judgment of the learned First Appellate Court, which has been exhibited as Exhibit 2, Exhibit 2, na? Exhibit 2. It is clear that the granting of the khatiyan under the Assam Temporarily Settled Tenancy Act 1971, for short the Act of 1971, in favor of the defendants was illegal? On the ground that the land was not an agricultural land? And further, the finding of fact arrived at that the defendants in those proceedings, who are also the defendants herein, were put in possession of a house by the plaintiff for doing business, running a tea shop, and it was on monthly rent basis. It further appears from a perusal of the plaint that on 9/3/1992, the plaintiff issued a notice asking the defendants to quit and vacate the house and premises described in Schedule A to the plaint, thereby removing the illegally constructed two thatched houses upon the land of Schedule B to the plaint, and also to pay an amount of rupees 7,920 on account of area rent in respect to the tenanted premises. Subsequent thereto, as nothing materialized on the basis of the said legal notice issued on 9/3/1992, thereby determining the lease, the suit was filed seeking a decree for eviction of the defendant number 1 to 7 from the Schedule A, from the house says described in Schedule A to the plaint, semicolon, a decree for eviction of the defendants number 1 to 7, etc., from the land described in Schedule B to the plaint by demolishing and removing the houses standing thereon, and a decree for area rent. Pursuant to the receipt of summons next, the defendant number 1, 2, 5, and 7 only participated in the trial. Only they participated, Mr. Burua, by filing their joint written statement.
And 7 also, Your Lordship.
Huh?
Joint written statement 7 also.
I've said 1, 2, 5, and 7.
Arindranath Deka and this 7, Your Lordship, they are brothers.
From a perusal of the written statement, all facts were denied, including the statements made in paragraph number 4 of the plaint. At the time of filing the written statement, the second appeal, which was filed against the judgment and decree passed by the learned first appellate court in title appeal number judgment and decree dated 27/11/1990 in title appeal number 49/1985 was stated to be pending. In paragraph number 11, the defendants duly admitted that the learned trial court entitled suit number 44/85 only decreed for cancellation of the Khatian. It was also admitted that the learned first appellate court held that the land comprises of a tenanted portion while the other portion is under forceful occupation of the defendants, and there has been no splitting up of the said lands. It was also stated that the defendants did not receive the alleged notice dated 9/3/1992 and denied the allegations made in the alleged notice. Taking into account the substantial questions of law which have been already formulated by this court now finds it very pertinent to take note of paragraph number 12 to 14 of the said written statement. The 12 and 14 of the said written statement. In paragraph number 12, the defendants stated that they have been occupying the land from time of their forefathers for more than 30 years on their own right and adversely to the plaintiffs. And as such, the plaintiff's suit is barred under Article 65 of the Limitation Act. In paragraph number 14, it was further averred that the predecessor in interest of the defendants occupied the suit land by constructing houses thereon and cultivating portion thereof. It was stated that the plaintiff had no houses on the suit land, and these defendants did not, and the defendants did not take any house of the plaintiff on monthly rental basis. It was further mentioned that the defendants are not tenants in respect of any houses of the plaintiffs, and as such, not liable to pay any area rent. It was further stated that the houses were constructed by the defendants and their predecessor, and they own the same, and these defendants have been occupying the suit land on their own right by constructing houses thereon for more than 30 years on their own right, openly and adversely to the plaintiffs. Therefore, from the very stand taken by the defendants, there is no stand of any forfeiture or breach of a condition which are necessary concomitants for application of Article 66 of the Limitation Act 1963. This court, moving forward, this court finds it relevant to take note of that on the basis of the pleadings, as many as 8 issues were framed. The issue number 2 related to as to whether the suit was barred by limitation. Issue number 3, semicolon. Issue number 3 pertained to as to whether the plaintiffs had any house on the suit land and whether the defendants had taken any such houses on monthly rented basis. Semicolon. Issue number 4 pertained to as to whether the defendants are monthly tenants in respect of the suit house described in Schedule A. Issue number 6 as to whether the defendant numbers 1 to 6, as to whether the predecessor of the defendant number 1 to 6 illegally constructed 2 thatched houses upon the suit land described in Schedule B. And issue number 7 as to whether the notice terminating the tenancy of the defendants was duly served upon them. While deciding the issue number 2, which is the issue pertaining to limitation, from a perusal of the learned, issue number. From a perusal of the materials on record, it reveals that both the plaintiff as well as the defendants adduced their evidence. Next. The learned trial court, by judgment and decree dated 5/2 to 1998, decreed the suit in favor of the plaintiff. This court finds it very pertinent now to take note of that while deciding the issue number 2, which was an issue pertaining to limitation, the learned trial court took the issue and decided the issue on the basis of Article 65. And came to the opinion that the question of applying Article 65 did not arise in view of the established landlord-tenant relationship between the plaintiff as well as the defendant. While deciding the issue number 3 and 4, the learned trial court, based on the evidence decided the said issues in favor of the plaintiff. The issue number 5, as to whether the defendant were defaulters, the said issue was also decided in favor of the plaintiffs. In respect to the issue number 6, which pertain to as to whether the predecessor of the defendant number 1 to 6 has illegally constructed 2 thatched houses upon the suit land, the said issue was also decided in favor of the defendant, in favor of the plaintiffs. In favor, said issue was also decided in the affirmative. Being agreed, come back, huh? Appeal memo. I'll put appeal memo. Did you enclose the appeal memo here? Mr. Dekha, mind to take out the appeal memo. And unauthorizedly constructing on 15/8/1975 2 thatched houses upon the vacant plot of land measuring 8 letters, which was a part of, which have been more specifically described in Schedule B to the plaintiff. However,
One more thing, Mr. President.
yes,
I'm also taking reliance on Exhibit 4 notice to show that it is a notice under 111E and not under 106 because they are themselves claim besides my defense side. Their case is based on forfeiture going by exhibit.
लिख ले last line को. And illegally constructed. In Schedule B. This court, however, finds it very pertinent to take note of. Paragraph number 9 of the written statement, wherein the said statement was denied by the defendants. Not only that, in paragraph number 12 and paragraph number 14 of the written statement, it is the categorical stand of the defendants that they have only constructed the entire houses. For Therefore, at this stage, this court finds this court finds it very pertinent to observe, opposite to observe, that in order to take the defense under Article 66, as already stated here in above, it is the defendant who has to prove forfeiture of the tenancy prior to the expiry of the lease period. The defendant having not admitted the tenancy, and on the other hand, having raised the claim of title on the basis of Article 65, in the opinion of this court, the entire case of entire defense under in terms with Article 66 is totally misconceived. Not only that, it is also very pertinent to observe that the defendants never raised the plea as regards Article 66. Throughout the proceedings till the second appellate stage. It is is a well settled principle of law. Has been held in Santosh Hazare versus Purushottam Tiwari, reported in 2001, 3 SCC 179. That in order that a question of law be a substantial question of law involved in the appeal, there must be a foundation laid in the pleadings. And the question should emerge from the substantial findings of facts arrived at by the court of facts. And it must be necessary to decide that question of law for a just and proper decision of the case. As there was no foundational facts raised in the pleadings, as well as also in the during the course of the proceedings till the second appellate stage, the question of applying Article 66 at this stage does not arise. In the backdrop of the above, now let this court take up Article 65. Tenancy Act. Assam temporary. Article 65, a reading of Article 65 would show that in respect to a suit for possession of an immovable property or any interest thereon based on title, the period of limitation is 12 years when the possession of the defendant becomes adverse to the plaintiff. Now the question arises as to how a plea of adverse possession can be proved. In the opinion of this court, to prove the plea of adverse possession, A, small a by Roman 1, the defendant must plead and prove that he was claiming a possession adverse to the true owner. B, number 2, the defendant must plead and establish that the factum of his long and continuous possession was known to the true owner. C, the defendant must also plead and establish when he came into possession. And D, the defendant must establish that his possession was open and undisturbed. The above is based upon when the defendant claims, takes the plea of adverse possession. However, in the case a suit is filed by the plaintiff seeking title on the basis of adverse possession, it would be for the plaintiff to prove so. Next. It is also very pertinent to observe, it is also a well-settled principle of law that by pleading adverse possession, a party seeks to defeat the right of the true owner. And therefore, there is no equity in his favor. After all, the plea is based on continuous wrongful possession for a period of more than 12 years. Therefore, it is of utmost importance that the facts constituting the ingredients of adverse possession must be pleaded and proved by the plaintiff, by the defendant. In the instant case, the plea of adverse possession has been taken at paragraph number 12 and 14 of the written statement, which this court have duly taken note of in the previous segments of the instant judgment. From the said paragraphs, it is not clear as to when the defendants entered into possession, and they categorically claim that they were adversely possessing to the rights of the plaintiffs. In other words, the defendants duly admitted the title or had considered, or by their admission, considered the plaintiffs as the true owner of the land. Now let us go take note of a very pertinent aspect, a very relevant aspect of the matter, which touches on the previous litigation. The Assam Temporarily Settled Area Tenancy Act 1971, for short, the Act of 1971, is an act to regulate the relationship of landlord and tenant in the temporarily settled areas in Assam. The grant of the Khatian, which the defendant, which the predecessor of the defendants, late Horendranath Deka, Horendranath, no, took along with the defendant number 7, our occupancy rights are rights as occupancy tenants. This Khatian, which was issued, was put to challenge by the plaintiffs in the year 1985, and the defendants, even after the decree passed by the first appellate trial court, continued to agitate their rights that they were entitled, they were rightly granted the Khatian till the second appeal, which was preferred, was dismissed in the year 1996. In the meantime, it is also very relevant that this Khatian, which is the occupancy tenant, as an occupancy tenant, the defendant claimed the plaintiffs as the landlord. And this finding of fact has been duly admitted, duly and this finding of and this had duly claimed the plaintiffs as the landlord. Inasmuch as the right of a khutian, or for that matter, an occupancy tenant, cannot be the host, the landlord. In view of the fact that the defendant continued to fight for the said khatian, which stood culminated only in the year 1996. And the present suit was filed in the year 1992. The question of the defendant agitating the rights or taking a defense under Article 65 is totally misconceived. Therefore, in the opinion of this court, neither Article 65 or Article 66 is involved in the instant appeal. And the learned trial court as well as the learned first appellate court had therefore have correctly opined while deciding the issue number 2. Next. The second substantial question of law is as to whether this, therefore, under such circumstances, the first substantial question of law so formulated is not involved in the instant appeal. The second substantial question of law pertains to as to whether the issue as to the question of tenancy and entitlement and the issue of eviction having already been decided in title suit number 44/85 and title appeal number 49/85, the present suit is hit by section 11 read with order 2 rule 2 of the CPC. এই আগৰ যে এইটো কৈছো নহয় এইটো যে it has already been the agitated this বুলি কৈ পেলাই এইটো যে ক'লো তাতে এটা লাইন এটা লিখি দিব. In fact, in paragraph number 10 of the written statement, the defendants categorically admitted that they are agricultural tenants. এইটো occupancy tenant কথা লিখিলো. The said substantial question of law, the said question of law so formulated cannot be regarded as a substantial question of law as there was no foundation laid in the pleadings. Even otherwise, the rights of the plaintiff over the scheduled land, scheduled properties, or suit property continued, and with the issuance of the notice on 9/3/1992, a fresh cause of action accrued. Under such circumstances, the substantial question of law so formulated cannot be said to be involved in the instant appeal. The third substantial question of law as to whether the defendant's possession in the Schedule B land is adverse irrespective of whether or not they are tenants in the Schedule A land have already been decided by this court while dealing with the first substantial question of law. And as such, it is the opinion of this court that the third substantial question of law also does not arise in the instant appeal. The fourth substantial question of law is as to whether the first appellate court erred in granting relief of eviction over the Schedule B land without determining the question of title over the same, and in absence of any relief for declaration of title over it by the plaintiffs. From the narration of the facts above and the respective pleadings, it is clear that the plaintiff defendants have duly admitted that the defendant's possession, it is duly admitted the ownership of the plaintiff over the suit land by claiming adverse possession against the plaintiff. The suit land not only comprises of the suit land is inclusive of Schedule B land, whereupon the plaintiff defendants claim to be in adverse possession. The filing of the claiming, the statements made that the defendants are agricultural tenants And there, wherein the plaintiffs are the landlords, does not require that the would not result in non-suiting the plaintiffs on the ground that the plaintiffs did not seek for declaration of their title. In that view of the matter, as the substantial questions of law so formulated does not arise in the instant appeal, the instant appeal therefore stands dismissed with cost quantified at rupees 3,50,000. How much we had discussed that day?
It comes to your lordship 4,80,000.
4 lakh.
Then he wanted 50,000.
Eh? At 35,000. 35,000 for the instant proceedings. The plaintiffs the plaintiffs further would be entitled to the cost throughout the proceedings.
Cost of rupees, your lordship.
Huh?
Cost of rupees.
Here it's 35 and you will be entitled to cost throughout the proceedings. It is. But Mr. Ali, I've given it in your favor, but it will be very difficult for executing. The reason is, I make it clear now only. You are only claiming the houses. Schedule A,
Little bit in
8
pleadings.
lessons in Schedule B. How do you do it as regards the others?
Little bit effect into pleadings, your lordship. Otherwise, the matter has been proved.
Huh?
Pleadings, there is little bit deficiency, your lordship. Otherwise, it is a big case. Or big deal.
That is your biggest problem.
You can trouble your.
Huh?
He might have to trouble your.
Why? No, no, no. I think that will be a headache for the executing court. With Schedule A, you are asking only the house. I didn't go to that aspect. That should have been actually his question of law.
Like,
What is this?
Revision against an order rejecting my application under Order 7 Rule 11 on the ground of limitation.
You took the point of limitation.
I have taken the
Let's read the plain.
plate start from page 21.
Hmm?
Page 21.
What was the suit for?
Suit for recovery of money, my lord, come out with suit. My lord will kindly,
Recovery of money.
my lord. The last invoice was of 2016. So that very suit is barred. Now what happened, my lord? They have taken a fee of acknowledgement in one paragraph because we issued a balance confirmation statement.
Hmm?
Balance confirmation statement.
Hmm.
Lordship and State will go to that document itself, page 72, my
When was the suit filed? 2023.
my
Admitted by ledger 1st of July, 46 lakh. Paid amount 28th of July, 10 lakh. Balance 36 lakh. Interest as on demand 44. So you say that he was only entitled to when? When was his invoice raised?
But last was 2016.
15.
16.
Ah.
So from that, the suit is otherwise barred. So what has happened, my lord? Document kindly turn to page 60.
60.
60.
Yes, that is what I am looking at. So there they say the admitted was on 1st of July 2018.
Yes, my lord.
If that is so, if let us admitted on 1st of July 2018,
It is barred.
bar,
Now
3
there is
years.
one more issue, my lord.
Or they
Then
have
sec-
paid in November 2008.
Yes, section 19 again. They have taken plea of section 19 also. That I have
Acknowledge.
made a part payment.
No, let us assume part payment.
Yeah.
Part payment also from 28th of November 2018.
Yes.
Then also,
Yes. Then also, my lord, there is one requirement that there is a proviso, my lord. They have said if it is counted from that day and Corona, that Supreme Court Kuomoto judgment, then possibly it may come. But my lord, Lordship is aware in the if they want to take the plea of section 19, then there is a proviso which says, my lord, that provided that say with the case of payment of interest made before the first day of January 1928, and acknowledgement of the payment appears in the handwriting.
yes, yes.
May I read the
Effect of payment on account of debt or interest on legacy.
They claim that in between we have made a payment of 10 lakh.
That is in the month of
That is on
28th November 2018.
20th November
18.
2018. Now,
The payment on
in
account
order
of debt
to-
or interest on legacy. Yes.
so they are required to show not only a payment, but an acknowledgement of the payment appears in the handwriting of or in a writing signed by the person making the payment. Now, what they have done, my lord, they have produced one document which is otherwise also illegible. Page 73 is the document.
Page
73.
Yes.
This is a document possibly is from the books of accounts or I don't know ledger book of their account, not our account, not dependents,
There is no signature.
nothing. And my lord, on top of that, my lord, so far as the plaint is concerned, your lordship kindly goes to para 59. Page 59, page 59, para 80.
What is this page 72?
Page 7. There is the balance confirmation statement. From that day, it is
No, what is this written in hand?
page 72. Written 2 installments, July 20, then.
That is their balance confirmation statement.
So from these days, they also admitted to this part.
From 1st of July 2008.
It is part. So they don't rely on this now. They go to this payment of 10 lakhs and the document is at page 73, only document, and it is their document, not from our account. It's from there, and they have the.
So it must have been paid by check.
RTGS.
So you must have mentioned.
I have said that they have paid it, and in fact, they have in the written statement has categorically admitted that they have paid your lordship. I will demonstrate that, which is annexed in this.
Well, I'm coming.
in this,
I'm conscious of that. I'm coming. There.
And we say that there is an oral agreement, which is to be proved in the by appreciating evidence.
Subsequent oral agreement.
Oral agreement for what?
Oral agreement was there that they will pay us the balance amount, your lordship. There was an oral agreement, we'll pay you very soon. We have served them an insolvency notice. And thereafter they came up and said that, okay, fine, we'll pay the amount to that extent. So there was an oral.
Where's your statement?
Yes, I have stated. Para 89, page 61. May I read, your lordship? After receipt of the said notice, the defendants represented and assured to the plaintiff that the entire and outstanding amount shall be paid by the defendants within the month of August 2021. As such, an oral agreement was entered into by and between the parties on 21st June 2021 at the office of the plaintiff situated Guwahati branch near Kumbarti Warehouse, Guwahati, within the jurisdiction of this court.
So this,
Then how do you take care of it?
but section 18 and 19 are the two sections. Oral agreement will come neither under section 18 nor under 19. Section 18 says oral agreement, by oral agreement, they want to say it's an acknowledgement. Now, acknowledgement has to be in writing. First, may kindly see 18, section 18. Oral agreement will not help them. This is a mere statement, nothing else. May kindly have a look at section 18. Where before the expiration of the prescribed period for a suit or application in respect of any property or right, an acknowledgement of the liability in respect of such property or right has been made in writing, signed by the party against whom such property or right claim, or by any person through whom he derives his title or liability, a fresh period of limitation shall be complete. So there is nothing in writing. Oral will not come within section 18. So far as 19 is concerned, 19 has got altogether different requirements.
Now, when the writing containing the acknowledgement is undated, oral evidence may be given at the
Yes.
time when it is signed, but subject to the provisions of.
All right. They are not claiming that there is anything in writing and they are giving oral evidence. They are saying
So therefore, you are saying about the Indian Evidence Act, section 91,
93.
where a document is required to be
Yes.
in written, then it has to be only written. You cannot use any other.
No. And my lord, now one more submission is being made that we have made a admission in the written statement. I'm taking a to that first. About the 10 lakh payment. This is the last date from which they are counting.
Where?
It's at page 90, your lordship, paragraph 38.
Huh?
Page 90. Paragraph 38.
Page 90, para 38.
Yeah.
That with regard to the statements made in paragraph 82 to 84 of the claim, the answering defendants take to state that the statement of the plaintiffs with regard to the meetings being held in Guwahati for release of payment is irrelevant in as much as no such meeting took place at Guwahati. The defendants paid a sum of 10 lakhs on 28th of November 2018 against the claim of the plaintiff, and further payment was not made due to non-settlement of the disputed bills, wherein the goods were supplied at higher rate. With regard to the balance confirmation statement dated 1/7/2018, the answering defendant does not admit anything contrary to the relevant record. This is the admission. Now they say the requirement is proviso to section 19. It has to be in handwriting, it has to be in writing, etc. Is this particular character where we have it. With regard to this matter, my submission is minor. And the Supreme Court has made it very clear that the exemption that you are claiming the Supreme Court has made it clear that exemption that you are claiming has to take place before the inscription of the suit, number one.
Before the period is over.
Yes, my lord. And before the inscription of the suit, writing has to be before the inscription, and the acknowledgement also may be a subsequent date, but again before the inscription.
Before the
it-
period, then only you get a fresh.
Exactly, my lord. And anything arising or happening after the institution of the suit will not help. And in that case, my lord, the fee they are taking,
Why do you need, it is written out here in 19 itself,
my lord.
where the payment on account of a debt or an interest on a legacy is made before the expiration of the period, prescribed period,
Yes,
by the person liable to pay, the
Right.
debtor so and so authorized a fresh period of limitation shall be complete.
but
So it has to end prior to that.
yes, and my lord, what it's not very clear as to whether such admission or etc. in writing, if made in the written statement, will also help them or not. But in that case, my lord, judgment, where the trial court said that no, there was an admission in the written statement, so it is a fulfillment of the requirement and of the provisos of section 19. Supreme Court said no, cannot be.
This is an order 711. Where
My lord, paragraph 10, my one paragraph would be enough. But while it is not necessary that the written acknowledgement, I will resume at 2 o'clock.
oh yeah.
I was reading paragraph 10 of the judgment. Paragraph 10. But while it is not necessary that a written acknowledgement should be made prior to the expiry of the period of limitation, it is, in our opinion, essential that such acknowledgement, whether made before or after the period of limitation, must be in existence prior to the institution of the suit. Whether a suit is time-barred or not has got to be determined exclusively with reference to the date on which the plaint is filed and the allegations made therein. The legislature has expressly declared in Section 3 Limitation Act that whether the defense of limitation is pleaded or not, the court is bound to dismiss the suit which is brought after the period provided therefore, in the first schedule to the Limitation Act. If the plaintiff's right of action is apparently barred under the statute of limitation, Order 7 Rule 6 CPC makes it its duty to state specifically in the plaint the grounds of exemption allowed by Limitation Act upon which he relies to exclude its operation. And if the plaintiff has got to allege in its plaint the facts which entitle him to exemption, obviously these facts must be in existence at or before the time when the plaint is filed. Facts which come into existence after the filing of the plaint cannot be called in aid to revive a right of action which was dead at the date of suit. The claim to claim exemption under Section 20 limitation earlier it was Section 20. The plaintiff must be in a position to allege and prove not only that there was a payment of interest on debt or part payment of the principal, but that such payment has been acknowledged in writing in the manner contemplated by the section. The ground of exception is not complete without the second element, and unless both these elements are provided to exist at the date of filing of the plaint, the suit should be held to be time-barred. In the plaint, as it was originally filed in the case when done the effect of the case, first will kindly come to para 8 1. This is what the present argument is made about the admission in the written statement. Admittedly, in the case before us, none of the payments specified above was endorsed on the bond itself, and there was no acknowledgement either in the handwriting or signed by the debtors prior to institution of suit. What the subordinate judge relied upon is the admission contained in para 15 of the written statement filed on behalf of defendants 1 to 3 in the present suit, where those defendants admitted not only that payments specified in the plaint were actually made on the respective date, but asserted that there were other payments besides this.
Mr. Sundar,
Manner.
as per the Supreme Court judgment, what does it say in that judgment of in WPC 3?
Yes.
It says within 3 months, if
I,
I'm not wrong.
I put it.
See the last portion of the
Madam.
judgment.
For that, my lord, Lordship may kindly see the page 99 in relation to the Suomoto judgment directions, I have made a chart, man. Page
Here
99
it
of my.
says, in cases where the limitation would have expired between the period from so-and-so to so-and-so.
Yes.
Notwithstanding the actual balance period of limitation remaining,
Madam.
all persons have a limitation period of 90 days from 1/3/2022. Page 4.
Page 4 here. Yes, 90 days. That longer, that period, longer, if it is more than 90 days, longer period will apply. And that calculation I have given in page 99 of my.
That is okay.
Huh.
But if did the period expire
Within, before 2721 in our,
if it has expired, then he gets
the entire period
till
from one.
the period is from 28 to 2022.
Yes,
Did his actual period expire?
yes,
Then he gets 3 months from there.
Yes.
Nothing more than.
Yes.
If he has a otherwise a longer limitation, it's okay.
Yes.
Then this has no relevance.
Right.
He doesn't get 3 months after the whatever I mean. So therefore, would your calculation at page 99 be right?
Yes, but according to your lordship, it will expire before that.
Yes. In my opinion, the limitation would expire prior to, would expire if his period of limitation ended.
I'm just reading it once again. In cases where the limitation would have expired during the period between 15/3/2020 till 28/2/2022. In our case, my lord, it has expired within this period.
Yes.
Now, notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 1/3/2022. Thereafter, my lord, in the event the actual balance period of limitation remaining with effect from 1/5/2022 is greater than 90 days, that longer period shall apply.
Yes. So therefore, if his limitation was just for example 100 or 200 days,
My lord.
even beyond 90 days,
My lord.
then obviously the 90 days would not apply.
Yes, entire period will come.
But did his limitation otherwise
My lord.
expire on 28/2/2022 if we don't take this judgment? Yes. If it expires prior to that,
Yes.
then obviously he will only get 30 to 90 days.
90.
Even assuming everything is right.
Yes. Yes.
Wouldn't that be the correct interpretation?
Right.
Because what the Supreme Court says, okay, whatever may be, this period, we are not extending or enlarging the limitation.
Yes.
We are not. What we are giving is only giving additionally 90 days, so that within these 90 days, you can take care of whatever is required.
Lordship will kindly permit me to verify what your lordship is saying from page 99 once again. The lordship allow me to just
Yes.
go from there. What has happened in this case? Balance confirmation statement will be a position under section 18. And that is 1/7/2018. From there, they will get 3 years. This 3 years period expires on 2/7/21. And I have calculated the days also, it is 1095 days. Now, limitation exhausted till 15/3/2020 as per Supreme Court judgment is by lordship kindly see from 1/7/2018 to 15/3/2020, 623 days. Am I clear, man? It started from 1/7/2018 and it will end on 2/7/2021.
No, what you have done is totally excluded that period.
Period. Well,
But that is not what has been mentioned here.
then we go to 1/3.
Yes.
The order dated so and so is restored and in continuation of the subsequent orders dated 8/3/2021, 27/4/2021, and 23/9/2021, it is directed that the period from 15/3/2020 till 28/2/2022 shall stand excluded for the purposes of limitation.
Yes. So that period will not be taken into consideration.
Yes.
But
But
if
in-
it expires,
Yes.
this is an exception to that. In case where the limitation would have expired during the period from so and so to so and so,
yes, before 28 to 2020, then
notwithstanding the actual balance of limitation remaining,
yes,
all persons shall have a limitation of 90 days from so and so. So he has to file within 90 days from there.
from 1/3/90 2020. But then next sentence possibly my
Yes.
subject to correction.
Yeah.
In the event the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that longer period shall apply.
Yes. Therefore, that
Hello.
if it is just for example,
My lord,
at the time when it is did not expire,
my lord. Somehow I'm not getting it, my lord. Lord, will you kindly see what calculation that I have done it, my lord.
Mm.
First, he gets 3 years from 1/7/2018 because of my confirmation statement. He has 1095 days.
Mm.
Then limitation exhausted till 15/3/2020 in terms of the judgment is calculated from 1/7/2018 to 15/3/2020 is 623 days.
Mm.
Now he has got, if we deduct 623 from 1095 days total, we have another 472 days remaining.
Mm.
Now, my lord, in terms of the third paragraph, this 472 days is longer than 90 days. And this entire period, it says longer period shall apply. This apply with effect from 1/3/2020. So from calculating 472 days from 1/3/2022, it comes to 16/6/2023. And he has filed the suit on 28/6/2023. There's a delay of 12 days. It's what objection.
so therefore you have excluded the entire period.
Yes. So in terms of the judgment, in terms of Supreme Court judgment, this from 1/7/2018 to 15/3/2020, whatever period has gone, that has gone. The remaining period he will be entitled from 1/3/2020, and that we have given to him. And if that is given, then his last date for filing the suit comes to 16/6/2023. Because it is more than 90 days. So from 1/3/2020, he will get a longer period of 472 days, remaining as on 1/3/2020.
Then what is the meaning of this number 3?
My lord, entire period we cannot exclude because his period has expired within that period.
That is what. How do
Yes.
you reconcile number 3?
Yes,
If,
my lord.
if that be so, if we are to exclude, then obviously 3 becomes useless.
No, my lord. Because see, if we plot it, reads 2. Consequently, the balance period of limitation remaining as on 3/10/2021, what we kindly see, if any, should become available with effect from 1/3/2022. In our case, my lord, limitation ended on 2/7/21 before 3/10/2021. So that is why we are covered by 3. It says, my lord, second, I'm reading again, second. Consequently, balance period of limitation remaining as on 3/10/21, if any, shall become available with effect from 1/3/22.
Now this 3/10/2021 is there is a reason behind.
Reason is because of one, my lord.
No, not only that.
Yes.
You see, 310 was the given earlier.
Yes.
As per the earlier orders passed by the Supreme Court, it was
28/2.
extended.
Up to 28/2.
28/2 came later on.
Yes,
This order came on 10th of
Exactly.
10th of January.
3/10/21 given by the last order.
Earlier order.
Mine.
Earlier order they gave the limitation till 310.
Yes.
So anything from 310 it is okay. But
Yes.
therefore the meaning
My
to
lord.
be ascribed to number 3
My lord.
has to be if during this period,
My lord.
if your limitation is over.
My lord. Because I'm trying to say that, my lord, as per Roman 3, in cases where the limitation would have expired during the period from 15/3/2020 till 28/2020, I am covered by that because my period expired on 2/7/21.
Well, notwithstanding the actual balance period of limitation remaining.
Yes. All persons shall have a limitation period of 90 days from 1/3/2020. 90 days. and if it's longer, then entire period. So in our case, according to me, my lord, they have a longer period of 472 days because before 1/3/2020, they have exhausted 623 days out of 1095 days in all. Now they have got a remaining period of 472 2 days, which has to be counted from 1/3/2022 because this is longer than 90 days. And that, if we calculate, the last date comes to 16/6/2020. One possibility thing is
No, if number 1 and number 2 is taken,
my
how does number 3 come into the picture? How can there be an expiry of limitation within this period?
possibly, my lord, subject to correction again. Very difficult to comprehend. My lord, Lord, kindly see once again Roman.
Yes, number 2 I've seen it.
Consequently, the balance period of limitation remaining as on 3/10/2021, if any, shall become available. So it says balance period of limitation remaining as on 3/10/21. And we cannot wait till 3/10/21 because it will expire before that on 2/7/2021 itself. So that being the position, will be covered by the third one. Because if we say balance period remaining as on 3/10/21, that means we are giving him an additional 3 months without any reason.
No. 3/10/2021 came because of this order. Kindly see number 1.
Minor.
You see, the order dated 23/3/2020, that is the first order
First order.
is restored.
I know.
And in continuation to the subsequent orders dated 8/3/2021, 24/3/2021, and 23/9/2021, meaning thereby certain earlier orders were passed.
Yes.
It is directed that a period from so and so to so and so.
Yes.
This is because of this order is passed on 10th of January.
Right.
Shall stand excluded for the purpose of limitation.
Right.
So if it is just, for example, your appeal was to be filed within 90 days, making it the example, this period of 90 days, you cannot take this period.
For
You need not
calculation.
file any appeal within this period.
Right.
Excluded.
Yes.
Therefore, you are getting a better of 90 days.
Right.
But how do you therefore reconcile if
Right.
you take within it?
Right.
Number 3, how can therefore, if we construe as per what you say,
Right.
that the entire period during this is to be excluded?
I am having the order of 29 also. Sixth page, Lakshmi kindly turn.
Kindly come here
My-
to the third 8, paragraph 8.
I am coming to paragraph 8 only. Paragraph
Paragraph 8.3.
3.
The
Before that,
period from 15/3/2020 to 3/2/10 to that shall stand excluded. Therefore, you have 3/10.
well, just 1 minute. Just paragraph before that, if it is clear. In cases where the limitation would have expired during the period from 15/3/2020 till 2/10/21, till 2/10/21, notwithstanding the actual balance period of limitation remaining, all persons shall have a limited period of 90 days from 3/10/21. Now, in our case, my lord, their period is expiring on 2/7/21 itself.
Absolutely. Therefore, he should have filed his suit,
File.
in my opinion,
File.
within
90
Uh,
days from 1/3/1920.
90 days from 1/3/2020. We issue notice and stay the process.
Wait, please, Your Lordship, I have a other submission to make, one submission to make. What my respected senior is saying, the date starts from 1/7/2018, but the date starts from 27 November 2018. Your Lordship. Because that was the date when they made a payment. Your Lordship, I have demonstrated from the written statement that from my statement as well as from the written statement filed by the petitioner before the learned court below, it is apparent that they have made a payment on 28/11/2018. But they are projecting that the balance confirmation starts from 1/7/2018. That will not be the period in my humble submission. The period will be 28/11/2018.
Let us assume that also.
Yes, Your
So,
Lordship. In that case, Your Lordship.
that's another 4 months? That's another 4 months?
Yes, Your Lordship.
So your period would have ended by when? Limitation would have ended by, would have otherwise ended on 2/11 at best,
28/11/2021.
21.
Now, that period will remain excluded. If Your Lordship, I'll just read the
That
order.
period only, whether it is excluded or not, you get only 90 days after that if it is expires within that period. You have filed later on.
Your
On
Lordship,
16, you filed the suit only on 28/6/2023. You should have filed it by 20/36/2022.
Your Lordship, subject to understanding what Your Lordship says,
We'll hear on that
in
later on.
case that the
We
limitation
issue
would have expired.
notice. We issue notice. Getting a notice out here is a very big thing. He's getting a notice. In other courts, in the meantime, stay, the matter would have been in the next slide. Issue notice, making it returnable. Well, it's a commercial suit. We need to do it early.
Early.
Issue notice, making it returnable on 13th of May, 2024.
30th of Monday.
Mr. R. Sinha appears on behalf of
Dependent number.
the respondent number, a sole respondent. Pustup. He has also filed a caveat for which the caveat stands discharged. Extra, here, it is also been brought to the attention of this court that Mr. R. Sinha have been duly served a copy. List the matter, list according. Oh,
Further.
this court further taking into account the issue involved. Further to that, taking into account that the instant application, taking into account that a decision made in the instant application this court have also taken note of the submission made by Mr. D. Mojumdar, the learned counsel, senior counsel appearing on behalf of the petitioner, that the pendency of during the pendency of the instant proceedings, the further proceedings of commercial suit number
135 of
CS 135/2023, pending before the Court of the Civil Judge Senior Division number 2, Kamrup Metro at Guwahati, is required to be stayed. He submitted that it would be an abuse of the process of the court and unnecessary and result in unnecessary judicial wastage of time if the said suit is permitted to be proceeded. In the circumstance, this application is allowed. So taking into account the above, This court is of the opinion that further proceedings of title suit number of CS number 135/2023 is required to be stayed, and accordingly, this court stays the further proceedings of CS number 135/2023 pending before the Court of the Civil Judge Senior Division number 2, Kamru Metro at Guwahati till the next stage. Mr. Mozumdar, I think I may be right,
I am reading again and again. When you read third paragraph.
because otherwise number 3 becomes useless.
Pause it, pause.
Yes, Mr. Pang, what is this?
So this is matrimonial appeal.
Hmm.
So your lord will find the judgment at page 22 much.
What happened?
But here, my lord, I'm against,
Divorce is granted.
yes, divorce is granted, my lord, maintenance, my lord, permanent alimony is granted 15 lakhs against him. So I'm only against that one. I'm not against the divorce, nor I'm against the maintenance amount of 8,000 to this extent.
IA is there.
No, my lord, no,
You are not asked for stay.
I'm praying for stay, my lord.
How?
I have an interim prayer in the, my lord.
Huh? Going to appeal con admit you.
So I may be granted.
What?
My lord, let me file an IA for
File it whenever you feel like. Admit you go call for a
I had a prayer, my lord, in the
for what?
appeal itself, my lord.
On the basis of your certificate.
All right.
My pleasure.
Yes, what is this?
Lordship, my written statement has not been accepted. Reason arising out of a land grabbing case that it was filed, so first civil aspect was dealt with. We appeared and written statement could not be filed due to this COVID period was going on. Thereafter, flood was there and court proceeded expert. Immediately on next day, we filed the written statement along with a application under order 927 prior for accepting our written statement. That has been expiry, so far as the expiry order, it has been allowed, but written statement has not been accepted. And next date is also fixed for timing of it. Page 55.
How many dates when should you have filed the application for filing the written statement, or when were you supposed to file the written statement?
We appeared on Lordship 28 1 2000 22 12 2021.
22/12/2021. Then
Then we got the copy. Copy was not furnished. It's 28 to 2022.
Huh?
So from that day, Lordship, 342 days. When we filed.
no, what is the date? You when did you get the copy of the claim?
28 to 2022.
28,
To 2020.
22.
20.
You got the copy.
Got the copy.
And
Then
when were you what was the next date fixed?
13 next date on 29/4/2022.
29/4/2022. What happened on that day?
We
took-
took time, Lordship.
Oh.
We took time.
Then
By this time, one and expired.
Then
Then Lordship 13/9/2020.
what happened in the meantime? 5 months.
29 after
In
29.
that period, Lordship, there was a flood, devastating flood in that town.
Okay. Then
13/9/2022,
when was the ex parte order passed?
29/2020.
2020? 29/2022. Where is that order?
Texting at page 25. On that day, we could not appear also. And the reason is
PO is on. Petitioner is present. OP was given an opportunity for 7 days in the last day to file their objection. Today, neither the respondent appeared nor filed their considering the ER to case will proceed ex parte for evidence. It's for evidence. Then what happened?
Then on next date, 28.
The Iman respondent has submitted WS and the same are received by the buyer. Respondent side has filed petition praying for vacating of the Iman again. So the next date you filed it.
File. And with an application.
And what is the case for?
It is a land grabbing case. Allegation charge sheet was filed by the police.
Land grabbing what?
Land grabbing of allegation of the this, respondent is that we have grabbed the land. This land.
Well, what land? How much?
Is the-
How much?
In FIR, there is nothing mentioned. What the quantum? There's 5 people or something.
5 bighas.
5 people.
Where?
It's still checked on.
Town. Okay. 50,000 cost. We allow it.
I'll leave it a lot.
50,000 cost.
Lordship, we have in our written statement, we have mentioned, we have inherited this land.
Very well. That is your written statement has to be taken into account.
No,
Cost.
that's our stand.
50,000.
Yeah.
This message should go round and clear that whenever a matter comes for this, I will allow it subject to cost. The cost will be depending on what is the land, where is the land, the gravity of where the land has been used. So accordingly, 5 bighas in Silchar town is 10,000 rupees per bigha. Makes it.
It may not be about the land lordship, about the delay, there is a delay.
Okay, give up.
Reasonable cost.
It's a case of land grabbing. It's not a small, it's a very simple case.
It needs, if lordship,
Chalo.
page 15.
Who?
15, page 15, this is the FIR lost by. He's
I'm not on that. You want this setting aside?
lordship.
Very well. We set aside 50,000 cost. Hello. This is an application. How many orders you have challenged?
Last order 24/5/2023.
This is an application under Article 227 of the Constitution challenging the order dated 24/5/2023 passed by the learned Special Tribunal, Kochar, in special bracket LG case number 21/2019, whereby the application filed for accepting the written statement was rejected on the ground that the respondent, the petitioner herein, who is the respondent in the said proceedings, could not have availed more than 90 days from the date of receipt of the notice. This court have duly taken note of that the petitioner herein as respondent appeared before the learned tribunal on 28/2/2022, and on that day the petitioner received the copy of the complaint petition, and accordingly the proceedings was fixed on 29/4/2022 for filing written objection. It is not known what transpired thereupon, but on 13/9/2022, another application was filed seeking time for filing written objection by the petitioner. The learned tribunal, as a last chance, granted 7 days time to file the written objection, thereby fixing 29/2022. On that day, that is, On the next date, that is on 29, 2022, the respondent, the petitioner herein did neither appear nor file their written statement. And accordingly, the case was fixed on 28/11/2022 for the applicant's evidence. It was also made clear by the order dated 29/2022 that the proceedings shall proceed ex parte against the petitioner. On 28/11/2022, the written statement was submitted by the petitioner along with an application for vacating the ex parte order dated 29/2022 and to accept the written statement. The applicant, the respondent herein duly had filed written objection by the impugn order dated 24/5/2023. The learned tribunal, taking into account that more than 90 days was availed by the petitioner herein, and then also did not file their written statement, had rejected the leave to for filing of the written statement. However, the learned tribunal set aside the ex parte order. The matter was accordingly fixed for framing of issues on 28/7/2023, and it is against the said order the present proceedings have been initiated. I've heard Mr. S.D. Purkayastha, the learned counsel, appearing on behalf of the petitioner, and Mr. R. Day appearing on behalf of the respondent. From the materials on record, it reveals that the learned tribunal, by the order dated 13/9/2022, and reveals that the petitioner herein duly received the complaint petition on 28/2/2022. Accordingly, the petitioner, therefore, was required to file the written objection oblique the written statement to the said application so filed. This court also finds it very pertinent to take note of that the remedy available under the Assam land grabbing, what is the act known as?
Assam Land Grabbing in bracket Prohibition Act 2010.
Prohibition Act, yeah, is a special statute whereby, in order to take care of the menace of land grabbing, a fast track procedure have been adopted so that the land grabbing, so that the civil, so that the dispute Not the dispute. It is, what is that? So that, what does it say in paragraph number 4? Give it to me. So that, so the due actions can be taken both civil on both by way of uh, civilly, due actions can be taken as per the civil laws as well as also as per the criminal laws upon the land grabbers in respect to acts of land grabbing.
Section 10 says that the civil liability has to be first.
This court also takes note of, now, under such circumstances, the period of 90 days, under such circumstances, this court further takes note of that Section 9 of the said Assam Land Grabbing Prohibition Act 2010 stipulates that the provisions of the Code of Civil Procedure 1908 and the Code of Criminal Procedure 1973 shall be applicable insofar as they are not inconsistent with the provisions of the Act. And shall apply to the proceedings before the special tribunal. Mutatis mutandis. And for the purpose of the provisions of the said Act. There's also a period given now within what time it has to be ended.
Completed.
Hmm?
Completion of the process.
It further stipulates in section 8(8) that every special tribunal shall dispose of the said proceedings as far as possible within a period of 12 months from the date of institution of the case before it, and the proceedings under subsection 6 of section 8 to be disposed of within 6 months from the date of framing of the charge against the person or persons responsible for the alleged commission or abatement of the offense punishable under Act. Therefore, strictly speaking, the benefit of 90 days, which can be granted in a normal suit, cannot be granted in a proceedings under the Assam Land Grabbing Prohibition Act 2010. Now, coming back to the facts involved, it would be seen that the petitioner herein states that it was on account of floods in the Silchar town, which was beyond his control, for which he could not file the written statement on 29/2022, or even appear. However, the learned trial court, the special tribunal, did not consider the said aspect of the matter, rather applying the principles as laid down in Order 8, Rule 1, rejected the filing of the written statement on the ground that the period of 90 days was long over. Under such circumstances, in the opinion of this court, full stop, it is also relevant to take note of that non-filing of a written statement in a proceedings initiated under the Act of 2010 not only renders the person concerned liable civilly, but also if a decision is arrived at that there is an act of land grabbing, civil criminal consequences will follow. This court have also taken note of that on 28/11/2022, the written statement was filed. It is the opinion of this court that as the written statement was already filed on 28/11/2022, the learned trial court, tribunal ought to have proceeded by taking into account the said written statement by imposing certain costs. Instead of proceeding with the said proceedings, or instead of proceeding in the said, instead of proceeding without a defense of the petitioner who was a respondent therein. Under such circumstances, this court, for the interest of justice, and more particularly taking into account that the written statement was filed on 28/11/2022, directs the learned tribunal to accept the written statement and proceed with the said proceedings and proceed with special LZ case number 21/2019 in accordance with law. Next. This court also is of the opinion that certain cost has to be imposed, taking into account the legislative intent of a proceedings under the Act of 2010, which visualizes the completion of the civil proceedings within a period of 1 year, and thereupon the criminal proceedings within 6 months. In the opinion of this court, a cost of rupees 50,000 is required to be imposed for the purpose of acceptance of the said written statement. Accordingly, this court directs the petitioner herein to deposit a cost of rupees 50,000 before the learned tribunal, special tribunal Kachar, Silchar, on the next date so fixed by this court, on the next date so fixed by this court. The payment of the deposit of the said amount of 50,000 shall be a condition precedent for the purpose of acceptance of the written statement. The applicant, the respondent herein, who is the applicant in the said proceedings, would be at liberty to file an application before the learned tribunal, so learned special tribunal, for release of the said amount, and on such application being filed, the learned tribunal shall permit the release of the said amount. Next. This court further, taking note of the order dated 17/7/2023, this court further vacates the order dated 17/7/2023. There is no stay.
There is no stay.
No stay.
What is the proceedings now? What has happened?
Whereas proceedings is not it is not continued because of this case.
Are you sure?
What?
What is the next date?
Next week,
You have the date?
yeah, just taking.
You give the date.
Lot well done.
It is made clear. It has been duly informed by the learned counsels at the bar that the next date fixed before the learned special tribunal is on so and so. And on the said date, the said amount of rupees 50,000 has to be deposited for the purpose of acceptance of the written statement. Failure to do so shall revive the orders dated 24/5/2023 and 29/2022. 29? Twenty-nine, 2022.
Give it to date.
Give it to him, no? Mr. Day, if in the meantime, if it is disposed of, then what will happen? Just find it out with the stage and let me know. Yes.
Next is a lot.
What is this FAO? And what is this IA for? Stay. Okay. FAO for?
The appellant, plaintiff, they filed a patent suit for right the claim interest matter. Being the legal heir,
You did not get.
no matter, we applied for partition. And that partition notice, your lordship will find that case 109 matter. Immediately after filing this partition petition before the circle office matter, notices were issued. The notice, the lordship will find that case 101.
So your thing is that they are constructing.
Yes, ma'am. Now, madam, after receiving the notice, madam, instead of appearing before the circle office, they have started the construction.
Why they will appear before the circle office?
Since the case has been, madam, also will only come to case number 101, madam.
Hmm.
If the notice issued to the third party, they have received this notice, madam. On 3 occasions, notices were issued, madam.
No, I'm not on that. What is happening in the meantime? Why can't you wait till 9/4? 9/4, the matter is fixed. It is against the notice.
But in
You are before his court. Yes. Why?
In the meantime, madam, what they are thinking behind, madam,
Hmm.
not waiting, madam. They may go to any extent, madam.
What is the value of the suit?
1 crore, madam.
Huh?
1 crore.
Then
Page. Page 30, madam. 30.
suit for what?
For right to the interest, madam.
Declaration of right title incurred, recovery of past possession, partition and permanent. What is this partition business? You are related.
Yes, madam.
Huh?
We being the legal heirs, madam.
Hmm. You are the who is constructing?
The opposite party, madam. Respondent.
Who is opposite party?
Respondent number 1 to 16, madam.
1 to 16. How are you connected with them?
Madam,
Huh?
the original owner of the plot of land was madam, there people already come to page 8, madam. The people,
No, how are you connected with them? Those people are some das you are pooch.
madam. The forefathers, madam. His name was late Motoram Post, madam.
Forefathers means how many generations before?
Madam, three generations.
3 generations before. Then? And now you remember.
No, madam.
You
The
can very
plot
well do.
was
Huh?
even taken, madam. The plot was taken, madam. Nothing was done. So, madam, when we approached the circle office for partition, madam,
Huh.
they started constructing the.
So the moment you approach, they started
Yes,
constructing.
yes, that's
Huh?
that's the difference, madam.
What are they constructing?
They are constructing a boundary wall,
Very well, good.
madam, and sometimes house, madam.
Sometimes your house, go, stay there. Stay out there. You did not wake up for 3 generations.
No, madam. Yes, madam.
Then
Because madam, that at that time, madam,
their name must have been there.
no, lordship.
In the record of rights, are your name there?
Yes, madam.
Where?
Madam, can we come to page number 116, madam.
Huh?
115, madam.
116.
115, 116.
Where?
Down below 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 14 line from bottom, madam.
11?
For 115, madam.
115.
Madam. For dust, it is number 1.
115, there is no name. What is it?
For dust is the petition number 1.
What is this AR Infra Private Limited? They are constructing. Hmm? Where is your name? Bharat Das.
Madam.
When did you enter your name? 21?
Madam.
When?
We entered our name on 22, madam.
Ah,
Of course,
yeah.
yes,
You
madam.
got your name and now you have raised.
Yes, madam.
No case. Yeah. Well, name and then. And I think some infra is constructing.
No, madam.
Who is constructing?
The responsible for construction of this party, 1 to 60.
Mr. Council, we will have this after view. Let us see what happens on 9/4. Nothing is there. It is not to be admitted now. Let's see what happens on 9/4. Because of the fact that the court did not.
Yes, ma'am.
It's only a house being constructed.
But without partition, how can they give the boundary wall? That is question number one.
They are giving the boundary wall for the no,
Mr.
Mr. Council, they are giving the boundary wall for the entire land.
Yes, madam.
So very well. You get a good delineated boundary wall. Or you want to spend some money on that. Very well. Because if I issue notice here, I won't give you any injunction.
This case also, madam. In this type of case, madam, doctor may also be this to dispose of, madam.
I can dismiss.
Dispose.
I can't dispose of, dismiss. You want that?
No.
That is why I'm fixing it after Bihu. Let us know what happens on 9.
Doctor may fix
The
it.
learned counsel appearing on behalf of the appellant submitted that as the next date is fixed before the trial court on 9/4/2024. Is the matter again on 22nd of April 2024. On that date, the learned counsel shall apprise this court as to what is the present status of the said proceedings, present status of the proceedings before the trial court.
Item number 3, a date may be fixed for after we, this is for.
What happened? Is it alive or not?
In fact, my lord, the date is not updated. That is the problem.
Find out whether it is alive or has it been disposed of. Find it out. If I pass a disposed of matter, asking for a written statement, it will have huge consequences. Find it out and let me know. And give them the number, they can also find. Yes. Next.
29.
Yes.
Is your lordship, my senior in election court number, another court, my senior is election another court lordship. My senior is election another court lordship.
Who is your senior?
Mr. A.M. Borgia. Mr. A.M. Borgia,
A.M. Borgia is in some other court.
Lord.
What are you challenging?
Your order dated 15/12/2022 is on page number. It starts page number 16, lordship. Authority part, the lordship may find at page number 63, last motion.
You are challenging which order? Page 60.
Page 60. Before going to the dispute order lordship, verify my take your lordship to the judicial order passed
Well,
on the last occasion.
Huh?
If lordship may see the judicial order passed in last occasion, lordship paragraph 6. The crux of the matter is there.
Oh, The executing court went ahead and did this. Can't do that. Yes, the senior. Okay, we'll have it on some other date. When is that? To stay. What is there to stay?
So execute the case was stayed.
Hmm?
Execute case was stayed.
At the request of the learning counsel for the respondent matter and adjourned to be listed again on 24th of April 2024. Interim order passed earlier stands continued till the next date.
Lordship was fixed on 24th of April.
30. May I please, your lordship?
Oh,
Lordship, in related to this matter, another application has been rejected. This is delay condemnation petition and another ex parte vacating petition, Lordship. So, two places were registered miscase and two orders were passed. And I have prepared two revision petitions.
very well.
So my humble prayer is this another revision petition 409/2023 may be taken and take any other date.
This is against what order?
Against my application for delay condemnation petition.
And it was rejected.
Yes,
What was the delay for?
delay lordship
For setting aside what?
ex parte order.
What ex parte order?
Ex parte proceeded against me.
In the
I am
suit.
In the suit. I have filed an application under order 9 rule 7. Along with that application, I have filed this application.
Very well. Now let us see what was the order of ex parte.
That expert, I have two separate orders, lordship.
Show me that order of ex parte.
Expert order that is lordship, that separate IAS.
When did the court went to the go to the question of ex parte?
About that.
You are the defendant.
Yes, your lord. Sole defendant, lord.
Where is the ex parte order?
Yes, your lord.
Which order? Got it. Today was fixed for filing written statement by the defendant and hearing on the petition under so and so. Defendant is unrepresented till so and so. Considering the what hearing on what petition? What is this 867?
867 petition. Oh, that is petition filed by the plaintiff. Some abatement petition was there. I have filed two petitions registered as miscase 112 of 2023 and another 113 of 2023.
So tell me how does section 5 come into the picture?
Because 30 days. 30
For
days
what?
Limitation is
For what?
for setting aside the order proceeding the suit expert.
30 days? But how can you imply under what provision the court proceeded ex parte? Tell me.
Order,
Court can proceed ex parte under what provision? Under order 9 rule 6? Isn't it?
yes, Lord.
But order 9 rule 6 or order 9 rule 8? Isn't it?
Yes, 6.
If it is under order 9 rule 6, order 9 rule 6, all these 6 ABC does not come. ABC does not come into the picture here because it's not fixed for hearing. The summons have been served.
Yeah.
He has not appeared. He has appeared. So the ABC doesn't come. So you can go to order 9 rule 8 or order 9 rule 8. Order 9 Rule 8 will only come when the plaintiff appear, defendant does not appear, isn't it?
No, only defendant when appear. Rule 8 comes only when defendant appears
See?
and plaintiff doesn't appear.
What is that? Order 9 Rule 8, what does it say?
Procedure where defendant only appears.
Then
And in that case, default, dismissal for default.
Then next Order 9 Rule 9?
Order 9 decree against the default, that bars face suit.
Suit, okay. So
Yes.
how do you proceed against the defendant? Ex parte? Order 9 Rule 6?
Rule 6.
Under what? It has to be a date fixed for hearing?
Yes.
Isn't it?
Yes.
Was the date fixed for hearing?
Because ultimately,
Where? Non-filing a written statement is a different consequence.
Hmm.
It's a different consequence. But whether Order 9 Rule 6 comes in,
it automatically comes because after what is the language? Procedure when only plaintiff appears. Where the plaintiff appears and defendant does not appear.
Hmm.
Where the suit is called for hearing.
Hmm.
Then
Hmm.
when someone duly served.
call for hearing.
Yes.
Is it fixed for hearing? Tell me. Understood. For the abatement application, call for hearing. That okay. He doesn't want to vacate that. Do you want to vacate that? No. Not as regards the abatement. You don't want.
Makes an order that suit shall be heard ex parte.
Yes. Then, how do you take care of that situation?
In this case, after getting someone, he engaged one counsel here.
Whatever it may be, he has
That-
appeared.
That counsel.
So, non-filing of a written statement is a different consequence. The concept out here is not there in Order 9 Rule 13, Order 9 of not filing of a written statement. It only goes on the concept of not on a date of hearing, non-appearance. So under such circumstances, how do you bring? Therefore, if it is date fixed for hearing, just for example, for cross-examination,
Yes.
or for filing of the evidence,
Yes.
he does not do so.
Yes.
Then otherwise he does not require.
Yes.
He only requires an Order 9 Rule 7 for the purpose of bringing it back to that stage, putting the clock back.
Clock.
Isn't it?
Yes.
So under such, how do you bring in Section 5? And why is Mr. Som filing all these type of applications? Hello, I don't have time today.
But maybe take
Both the
along with MI CRP number 409.
Okay. I heard Mr. A.R. Som, the learned counsel for the petitioner, and Mr. B. S. Sahu appearing for the retired. The learned counsel submits that along with the instant proceeding, there is another CRPIO 409/2023 to list both the matters together on 24th. Yes. Yes, some affidavit has been filed.
I have all everything.
Chalo, we take it up when?
If possible.
9? 9 time tight is
Maybe after view vacation.
we have it after Bihu, 23rd?
My stay is vacation. So it can go.
On 9. Hello, let's have it on Tuesday. It's a partnered matter.
Pleading complete. Pleading complete. My on 23rd, I will be out of station, madam.
But you said this.
Tuesday you will be here.
Yes, and then on 23rd.
At the request of the councils, the matter directed to be taken up on 9th and listed at top of the list.
Only my name may be reflected. Has not been reflected in the causes.
Give your name properly.
আমার তো প্রবলেম এটা হলো
Hello.